And I want to talk about the defense case. And we've got some video of some of that I want to play. And then I want to discuss Kristen Adamson, who was a lawyer for Wendy Adelson. The defense has called her as one of their witnesses. She testified, among other things, that she would not describe this divorce as contentious. And of course, that's a big piece of this case. It's a big part of the motive that the prosecutors are alleging. Let's play SOT 1 and then we'll get into that.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
All right, guys, look, I want to get your thoughts on it, but let me tell you real quick some of my thoughts. I question this testimony. I mean, look, it's a divorce case. These lawyers are coming into court saying that, divorces are not contentious, but how are they supposed to be the ones who are the arbiters of what is and is not contentious? I mean, that's a subjective sort of descriptor of how the parties get along or don't during the process. And I don't know how they're supposed to be in the minds of all the players deciding what's contentious and what's not. Dave, you're a Florida lawyer. What do you think about this, and is that a good defense strategy?
It's a terrible defense strategy, Phil. You're talking about lawyers who are really experts in this area of family law that have had many, many cases, and yet we're supposed to take their word that this is not a very volatile case. It's not a contentious divorce. Well, it was to them. Maybe to the garbage man, the trash doesn't smell. But to the resident who's not used to picking up trash on a daily basis, it reeks, okay? And that was an example that Georgia Capman gave, and she was right. And that's why she was so hot on this witness and going after her on cross, because it really is a poor defense when your whole thing is to put one over on the jury to make them think that there's nothing to see here, that this was just a run-of-the-mill divorce. Really, in run-of-the-mill divorces, do you try to first bribe them for $1 million and then threaten to dress the kids in Nazi uniforms and then end up sending hitmen up to kill them? Now, of course, the defense is saying, well, there was not the hitman part. Everything else is true. Okay, I've never heard of a custody/relocation battle that got this nasty. And besides, even if it is run-of-the-mill to the lawyer, to these individuals, it is impossible to claim that it was just ho-hum to them. To them, it meant everything.
Yeah, and look, I briefly in my legal career, I took in some family law cases, did some stuff, and it became very obvious to me very quickly that people are emotionally invested in the subject matter, and they wanted me as their lawyer to be as emotionally invested as they were, which is why I can't do it anymore, because I can't get that much into their emotional stuff like that. But, they've got this witness, Jonna, who's testifying that compared to other divorce cases, she didn't call it contentious, but that doesn't really, I don't think that's going to play well with the jury. Jonna, your thoughts?
I call bullshit. And here's something else. If I'm representing Wendy Adelson as her divorce attorney at some point in this, and we know that Wendy Adelson has mysteriously not been charged in any of this crazy crime, you would have to not just subpoena me to come and testify, you would have to haul me in with a police escort while I'm grabbing onto the leg of my desk because I am not going to go willingly. I wouldn't want any part of this case. I don't care who wanted me to testify. So why this attorney chose to take the stand, knowing full well that the motive in this case, right, the motive that the prosecution is trying to present is that it most certainly was a contentious action. You don't fight. You don't file motions over where your children are going to lay their little heads without it being contentious. Don't try to pull one over on the jury by bringing in a lawyer to say, no, we've had plenty. No, it was fine. It wasn't fine. So not only was this a bad witness for the defense, it was a bad idea for this lawyer.
Well, they didn't stop there, did they? Because we had more testimony from another lawyer who they qualified as an expert. But before we get into that, they had an issue over what's called the rule of sequestration. So let me set the stage on that. So the rule of sequestration, each state has some slight maybe differences in how it's applied. But what it means is that witnesses aren't allowed to be in the courtroom to watch other witnesses testify. They can't even be in the courtroom. Maybe if they get released from their subpoena, they can come in. There are some limited exceptions to that, but the idea is that you don't want one side's witnesses all getting their story straight and sort of making sure their testimony jives and overlaps just properly. So that's called the rule of sequestration. There's an exception. If you have an expert witness, the judge can, in the judge's discretion, permit an expert to be in the courtroom to watch the testimony of another expert so they can compare whether or not they agree. So that's an exception. But guys, we had another attorney who was going to be testifying for the defense, who was in the courtroom for Kristen Adamson, Wendy's lawyer's testimony. And she wasn't testifying as an expert. So we had some drama. We've got SOTs 2 and 3. And can we play those back to back? And when we finish with this video of the judge and how he deals with this rule violation, I'm going to talk with my panel about it.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. At a minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
Yeah, she would like them to stop violating the rule of sequestration. I could go several years in any kind of courtroom proceeding that I deal with, and this never comes up because it's always followed. Very rarely do you see a violation, and it's usually something that's rather minor and usually not on purpose, but I can't tell if this was a purposeful violation or not. But Dave Aronberg, this was setting up for Linda Bailey. Now, Linda Bailey is a family law attorney, and look, here she was hired by the defense to determine whether this was, in fact, a highly contentious case. This seems to me like something the jury can sort out, Dave, on its own, whether it's contentious. We don't need a lawyer with decades of experience in family law who is used to this kind of stuff. We don't need that person to tell this jury whether it's contentious, do we?
No, and this shows the weakness of the defense. First, they start off with character witnesses. That's not usually the foot you want to lead with. That's usually the thing you do on the back end after you've shown some defense, but that's the best they had. And then they followed up with these two lawyers. Now, just to correct, earlier I said that Georgia Kaplan just eviscerated the lawyer on the stand. This is the one, Miss Bailey, the second lawyer. That's the one she went after in a big way. It's like she took it personally. And I think essentially what this witness was trying to say is to the jury, who are you going to believe, me or your lying eyes? Because the jurors understand that this was a contentious divorce. And no matter how many times they can get wrapped up in legalese, they're not going to be swayed by this. And I think it's a poor defense to try to convince these jurors that this was a run-of-the-mill divorce when there's ample evidence, a mountain of evidence that says otherwise.
Well, since you mentioned it, can we call for SOT 4, which is the cross-examination? Skip ahead a little bit. This is Georgia Kaplan who, goes after this witness, and then we'll see what Jonna has to say. But let's roll SOT 4.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question.
All right, so just strike the question. Jonna, I think she did a good job making her point, but setting aside the issue of the failure to ask leading questions on cross-examination, I guess that's just her style. She's a great lawyer. I'm not trying to be overly critical, but she asked open-ended questions and got this so-called expert who is clearly serving more in the role of an advocate versus just an expert witness. She allowed her to get some extra material in there that was really not what the prosecutor wanted to get out of her because she failed to ask leading questions. But that's my miniature rant. Jonna, so what is your take on all of this? Should this witness have been allowed to testify as an expert? And what do you make of her testimony? Because remember, she says that she can glean whether or not this was contentious or not simply by reading the cold paper filings in the court's file.
Yeah, I'm very surprised that she was allowed to testify at all. This is not really a traditional subject of expert testimony, number one. And what the prosecution was trying to point out is a very valid point. Look, you can't sit here and sort of coldly textbook this because it's going to be different for everybody. But let's go bigger than that. This point that the defense was trying to make, I think what they were trying to do is say, look, this really wasn't a contentious divorce, so there's no motive for Donna Adelson to want to pay anybody who's not on her payroll, to want to have a hitman come and kill her son-in-law, to want to pay him $1 million if he'll just relent and let the children move to Southern Florida. It wasn't contentious, so there's no motive for that. Motive is never an element of any crime. So the defense did not hammer home that there was a lack of motive. So why did they even look at Donna Adelson? There are so many other dots that the prosecution, I feel, successfully connected that this motive issue is really a nothing burger, as much as I hate that phrase.
No, it really is because, see, the prosecutor has said that Donna Adelson, she's the defendant in this case, they said that she had motive to kill because there was a pleading filed that sought to have to limit her visitation with the grandkids to something where, no unsupervised visitation. So that was basically a missile fired in this litigation directly at Donna. So the prosecutor saying that's the motive. The defense is rebutting that by saying that Wendy had no motive because Wendy's divorce was not contentious. And it's like apples and oranges, and the whole thing is now so convoluted. But I do think the defense has missed the mark on that one.